This lecture is about law and the Quran. In this lecture, I will explore the nature of the Quran as a source of law and the types of laws found in the Quran with some examples. I will look at specifically a number of examples of law related texts in the Quran and how Islamic law is closely connected to the Quran. I will use the example of women and law in the Quran, particularly how the Quran dealt with some pre Islamic practices concerning women and how the Quran changed them. The Quran has a lot to say about what we might call law, LAW. We often hear about terms like Islamic law or the Sharia, Sharia. Many Muslims and non Muslims use these terms often interchangeably. Sometimes, when we compare Islamic law with the law of another country, for example, Australian law or French law or Singaporean law, we get the impression that we are comparing two similar legal systems. Islamic law versus Australian law, for example. What do you think? In what ways are Islamic law and Australian law similar, and in what ways are they different? Let us look at these two terms, law and Sharia. First, what is law? What are some of the different understandings of the term law? Let us look at a couple of definitions. Law can be thought of as the system of rules that a particular country or community recognizes, which regulates the actions of its members. Law may be enforced through penalties, or it can be described as a rule that comes from a legitimate authority and applies to everyone. Laws are created to make sure that everyone understands what is expected of them as a member of society, that is, their obligations, and what they can expect of others, including government, that is, their rights. The key words here are system of rules, particular country, regulation, obligations, enforceability, and penalties. So, what is Sharia? There are many definitions of Sharia. Here is one example. Sharia may be defined as the totality of God's commands and exhortations, intended to regulate all aspects of human conduct and guide believers on the path of eternal salvation. The sources of Sharia are the Quran and Hadith. Another definition of Sharia is that the term Sharia describes both Muslim practices that relate to law in Western understanding and others that do not. It is better understood as the Muslim conception of a life in conformity with God's will. Therefore, this includes both the rules that regulate the Muslim's relationship to God, such as the ritual practices of worship, that is, prayer, fasting, pilgrimage, and so forth, and the rules that regulate the worshippers' relationships to one another and to society. So, from these definitions, what are the similarities and differences between law and Sharia? Are there any differences? What do you think? Do Muslims agree on the meaning of Sharia? How do different Muslims understand this term? One Muslim scholar defines Sharia as how to be and remain Muslim. This is obviously a very broad definition. Another Muslim scholar describes Sharia as the wide ranging moral and ethical principles drawn from the Quran and the practices and sayings of Prophet Muhammad, that is, Hadith. So he goes on to say that these broad principles are interpreted by jurists to come up with specific legal rulings and moral prescriptions. The body of legal rulings that emerges from the interpretation of Sharia law is commonly referred to as Islamic law. For some Muslims, Sharia simply equals law, a Muslim should follow, or what is referred to as Islamic law. And this is broadly understood by many Muslims. For other Muslims, Sharia is a lot broader than what is referred to as law. For them, Sharia is more about rules, regulations, ethical and moral values and norms, as well as the belief system and expected practices a Muslim is expected to follow that covers all aspects of one's life. In general, Sharia is what should guide a Muslim's life. This is obviously a very broad understanding. It is a lot broader than law as we know it, or even what is called Islamic law. Well, can you think of another definition of Sharia? What could that be? In a country like Australia, when we talk about Australian law, by and large, we are talking about something that is very specific. It is really what we as citizens or residents of this country must do and must not do. Sharia covers what a Muslim must do and must not do, but much more. Under the broad label of Sharia, all of a Muslim's actions fall into one of the following 5 categories. First, what a person must do, that is, what is obligatory. Second, what a person must not do, that is, what is prohibited. Third, those things, well, it is a good idea for the person to do. In other words, those things that are recommended. Fourth, those things that, well, it would be a good idea for the person not to do, or what is referred to as disapproved of. And fifth, those things that are simply permissible. And this is the broadest category. As you can see, this is not how Australian law, French law, or American law, or British law works. In these legal systems, the system is only interested in 2 things: what a person must do or must not do. So, is the Quran a book of law or a book of laws? Some Muslims might say yes, others might disagree. To some extent, the Quran can be considered a book of law, but the bulk of its texts, or the vast majority of its texts, are not about law. There are some texts in the Quran that could be considered law, depending on how narrowly or how broadly we define law. But even then, the label law applies only to a relatively few Quranic texts. Strictly speaking, the Quran is not a legal text, but it has been used by Muslims over the last 1400 years as the most important basis for what is called Islamic law. In terms of the quantity of texts in the Quran on legal issues, out of approximately 6,200 plus Quranic verses, there could be anything from 80 to 100, 200, 300, 400, or 500 verses that are law related. This is because much depends on how we define law. If we define law as narrowly as rules and regulations that govern what a person must do or must not do, the number of verses could be relatively small. It could be closer to perhaps 100 or 200. But the Quran is interested in something a lot broader. It is concerned about what it calls, for example, in Arabic, amal salih. In other words, in translation, the right action, or the good deed, or the good behavior. There is a lot of emphasis on right action and good deeds and good behavior, or in Arabic, amal salih, in the Quran. Not often define what right action is or what good deeds are. Often it gives examples of right action. For example, helping the poor and the needy, spending, telling the truth, keeping promises, giving a loan without interest to a needy person, being honest, giving each person what is due to them, treating a person, being fair to others, being just, and so forth and so forth. These are just some random examples. There are many more. Of course, this doesn't mean that there aren't rules and regulations in the Quran. They do exist, but they are often expressed quite generally. For instance, if you look at the area of criminal law or Islamic criminal law, the Quran says, for example, the person who steals or commits theft should have his or her hand amputated or cut off. But it doesn't actually define what theft or stealing is in a legal sense. It doesn't give details about where the hand should be cut or under what circumstances or conditions this should be done. Muslim jurists or experts in the area of Islamic law had to interpret these very brief texts in the Quran and work out what they meant. When the Muslim state needed such laws, in the past they had to resort to the thinking of Sharia experts or Islamic legal experts who interpreted what the Quran and the Prophet had to say on such matters. How did the Muslim jurists produce law? If you look at how Islamic jurists or Muslim jurists in the past produced law, it is quite different to the way law is produced in a country such as Australia. In Australia, individual academics or scholars do not produce law. It is primarily the job of the parliament, or in some cases, the job of the judges or the courts. Production of law is a state function. It is not for individuals outside state institutions to do that in a country like Australia. Of course, the production of law in most Muslim majority countries these days is also a state function. But in earlier times, Islamic jurists as individuals developed and produced what we call Islamic law. These works were then used by the state and implemented where relevant. So, what you see is in the first 200 to 300 years of Islam, in particular, many Muslim scholars and jurists had to interpret texts of the Quran and the traditions of the Prophet, that is, Hadith, in a way that could become law and be applied by the state, that is, in certain areas, obviously. In doing so, the jurists had to interpret particular words or phrases in the Quran and Hadith. They had to come up with very clear definitions and had to examine other texts like Hadith to see if such texts were also relevant to interpreting the Quranic texts that they were dealing with. For example, there could be many hadiths on a particular legal issue, say the issue of theft or stealing I mentioned earlier. The jurists had to bring all these hadith texts together that are relevant to theft. They also had to look at how similar issues were dealt with by earliest Muslim judges or Muslim rulers and how other Muslim jurists before them thought about such texts. They had to look at how other decisions that were made by earlier scholars or judges were related to the case they are dealing with, and what other opinions that might exist on the matter. They had to consider the different practices related to the issue in the past, and they had to take into consideration the context in which they themselves were living and what was practical or feasible. I gave the example of theft, but this can also be related to currency exchange, marriage, divorce, and contracts, for example. Of course, at the heart of the debate was what the Quran appeared to be saying on a particular issue. For example, the Quran prohibited, as I said earlier, theft or stealing. For the jurists, they would not go away from the basic idea that the Quranic text expressed. So, as a matter of principle, theft or stealing is prohibited. But they would try to find ways of broadening or narrowing the scope of what the Quran was saying. They had to work out how best to utilize the instruction provided in the Quran while keeping an eye on other considerations I just mentioned. So they had to do a lot of work in order to convert the few Quranic references or texts into what we call specific laws, rules, and regulations. This was not just a simple matter of reading a particular Quranic text, then saying, oh, this is the law. A long process of work is involved. With reference to the example I gave earlier about theft or stealing, the jurists had to define what theft was in a legal sense, in an Islamic legal sense. They had to work out exactly what conditions should be met before someone's hand was amputated as a form of punishment, what kind of evidence was required for this to happen, and many, many other issues, extremely complicated issues. Obviously, the Quran did not go into these kinds of details. It was the jurist's job to interpret the Quranic text and basically convert it to what we understand as law or rule or regulation. There is obviously a lot of work involved in doing this, that is, in converting a specific text on a legal issue to a law that the state could apply, or in the case of individuals and their own practices, what an individual could apply. It was a long process with many principles and tools and methods to be applied. These tools came from another Islamic discipline, which is usually referred to as the principles of jurisprudence, or in Arabic, usulul fiqh. These principles are largely about how to understand and interpret the texts of the Quran and Hadith, and how to develop rules, regulations, and laws. Without the knowledge of these principles and methods and tools, it would be difficult to convert Quranic texts into law or Islamic law. So, what do you think the process was for a jurist to take a Quranic text and interpret it so that it became a law or a rule? Well, let me just give some examples very briefly. If you open any Islamic legal text or legal textbook, you will find a vast array of chapters on Islamic legal issues. For example, there will be chapters on rituals and worship such as prayer, fasting, and pilgrimage, and ritual purity. You will find chapters on prohibition of certain types of foods, for example, wine, blood, and pork, and ham. You will find chapters on fighting and rules of warfare, or commercial and civil matters, such as interest on loans, property, testimony, and transactions such as buying and selling. You will also find chapters on family issues such as inheritance, marriage, divorce, or slavery and freeing of slaves, and also chapters on criminal offenses such as homicide, bodily injury, or theft, and also chapters on lending and borrowing. So, in classical Islamic legal texts or textbooks, the jurist would start off by discussing ritual purity or cleanliness and how a Muslim should make themselves ritually pure, for example, before performing the prayer. What kind of water could be used for this purpose? Running water, for example. But what if the water that is available is not very clean? How do you wash yourself? What if there is no water at all? Can you use something else? This is an interesting way of beginning the work of a classical Islamic legal text or a textbook. The jurists will the jurists will then go on to explore topics such as how to pray, how to fast, particularly during the month of Ramadan, and how to do your pilgrimage to Mecca, and how to pay your zakat. By the way, zakat is paying a certain percentage of your savings or wealth to the poor and the needy and to the community. There will be chapters dealing with what we might call strictly legal issues, such as marriage and divorce, child custody, mortgages, punishments for specific crimes, war and peace, and many other such topics. The jurists tried to provide a pretty comprehensive guide not just for the individual Muslim, but also for the state to apply. But we should also keep in mind that a large part of what we call Islamic law can be applied by the individual without any need for the state to be involved or to help apply it. But there are also areas of law where the state must be involved. For example, in the case of criminal law or family law or contracts. So, in some cases, the state applies the law created by the Islamic jurist through its judges. I want to search for an Islamic legal text available online with the title of The Distinguished Jurist's Primer by a scholar named Ibn Rushd, IBN RUSHD, and see how he organized this very important legal text. It comes in 2 volumes, and the PDF version is available online. Now, think of a Muslim majority country today, such as Malaysia or Saudi Arabia, and find out how Islamic law is produced or constructed today there. Let us now look at the different kinds of texts or verses in the Quran that are related to Islamic legal issues. Please keep in mind that when I use the term Islamic law, I'm using it in a very broad fashion. And this term covers not only strictly legal issues as we understand these issues in a country like Australia, but also many other issues, such as those I mentioned earlier in the lecture. When we talk about law, we also need to talk about ethics. Law and ethics are closely connected. In the Quran, this connection is very important because its concern is often very much about the ethical and moral dimensions of an issue. The Quran is often concerned about what it calls righteousness, ethical conduct, and moral behavior. Strictly following a particular ritual without giving consideration to the ethical concerns that are connected to it is a bit foreign to the Quranic treatment of legal issues. So, law and ethics must be closely connected when we are discussing or thinking about Quran and law. Now, this can be seen in a very well known Quranic verse, which is Surah 2 or chapter 2, verse 177. And it reads in translation: Righteousness is not that you turn your faces toward the east or the west, but true righteousness is in one who believes in Allah or God, the last day, the angels, the book, and the prophets, and gives wealth in spite of love for it to relatives, orphans, the needy, the traveler, those who ask for help, and for freeing slaves, and who establishes prayer and gives zakah, those who fulfill their promise when they promise, and those who are patient in poverty and hardship and during battle. Those are the ones who have been true, and it is those who are the righteous. What do you think this verse is trying to say? How important is this in other Quranic rules, regulations, or laws? Can you think of a strictly legal issue the Quran has dealt with and see if its concern about the ethical and moral dimensions is absent? As I mentioned earlier, the Quran is very concerned about good deeds and right action or the good behavior. One ethical dimension of this is the issue of justice. The Quran spends a lot of time on the issue of justice. There are a lot of texts about justice. Some ask Muslims to be fair or just, even if it means going against their own families. So, what is justice? Scholars, philosophers, and theologians have discussed this for centuries without coming to an agreed upon definition. Mostly, we associate justice with what we consider to be fair. But again, this is very context dependent, isn't it? Slavery is a good example of this. It was considered fair and just in the past, at least in many societies. Even at the time of the Quran's revelation, there was slavery, and the Quran tolerated it to some extent, but encouraged Muslims to free slaves. It did not, however, prohibit slavery at the time. But today, slavery is contrary to our value system. We, that is, Muslims and non Muslims, don't accept slavery in any form, although certain forms of slavery still exist. This means, in relation to an institution like slavery, our values have changed over time. There are plenty of other examples too. Societies change and values change, and we need to find a way to accommodate that in our thinking and when we engage with the Quranic texts, for example. So let us return to the types of legal concerns the Quran dealt with. Obviously, I will not be comprehensive, but the idea is to give you some sense of the kinds of texts that are in the Quran on Islamic legal issues. Many times, the Quran does not attempt to provide many details or specifics. Much of that is left to Prophet Muhammad to explain to his people or to show how it should be implemented in practical detail. That was the Prophet's job, to explain and provide details and implementation. So, what are some examples of legal verses in the Quran? Let me give some examples. Chapter 4, verse 2 says, "Give orphans their property, do not replace their good things with bad, and do not consume their property with your own, a great sin." Chapter 4, verse 19 says, "O you who believe, it is not lawful for you to inherit women against their will, nor should you treat your wives harshly, hoping to take back some of the bride gift you gave them, unless they are guilty of something clearly outrageous. Live with them in accordance with what is fair and kind. If you dislike them, it may well be that you dislike something in which God has put much good." Chapter 2, verse 196. "Complete the pilgrimages, major and minor, for the sake of God. If you are prevented from doing so, then send whatever offering for sacrifice you can afford, and do not shave your heads until the offering has reached the place of sacrifice. If any of you is ill or has an ailment of the scalp, he should compensate by fasting, or feeding the poor, or offering sacrifice." Chapter 5, verse 5 of the Quran is an example of a text that deals with dietary laws. And it says, "Today the good things are permitted to you, and the food of those who are given the book, that is, Jews and Christians, is permitted to you, and permitted to them is your food." Chapter 2, verse 282 is an example of a legal text that deals with contractual matters. It says in part, "O believers, when you contract a debt between yourselves for a stated term, write it down, and let the writer write it down between you and justly." This verse encourages people to document things. This is about evidence, so there are no disputes later. But The question is it a command to Muslims to write things down whenever they engage in this kind of transaction? Or is it simply a piece of advice? Let us look at law as imagined by the Muslim jurists. For the Muslim jurists, Islamic law is based on two important sources or texts: the Quran and the traditions of the Prophet or Hadith. They believed what we call Islamic law should cover all aspects of a Muslim's life. Nothing is excluded. But the question is, do the Quran and the traditions of the Prophet provide detailed guidelines on every aspect of a Muslim's life? What do you think? The short answer is no. Obviously, there are quite a few guidelines, rules, and regulations, but they do not cover all aspects of a Muslim's life. So, for the jurists, there was a major job to do. That job was to construct a system of laws, rules, regulations, and guidelines on how to live as a Muslim. They relied on the Quran and Hadith, but also on a wider range of other material. For example, pre Islamic practices tacitly accepted by the Quran and the Prophet Muhammad, practices from other systems of law and justice, as well as what we may call independent reasoning, or in Arabic, ijtihad, relying on certain principles, methods, and tools. All of this came under the spirit and umbrella of what we call sometimes Sharia or sometimes Islamic law. Perhaps it would be a good idea to have a closer look at this issue: how Islamic law emerged in early Islam. As you know by now, pre Islamic Arabian society was tribal. There were some settled tribes, while other tribes were nomadic. But they all had rules and punishments for various crimes: personal conduct, intertribal relations, commercial and trade related issues, and even family related matters. The Quran and the Prophet Muhammad accepted the bulk of the legal norms, values, rules, and regulations that were in society at the time. It was only when the Prophet's message conflicted with certain practices or rules or regulations or norms that the Prophet asked for a change, or the Quran asked for a change. We will discuss one example of this in a minute when we look more closely about what the Quran says about marriage, for example. Obviously, the Quran did make changes to pre Islamic Arabs' practices, norms, rules, and laws. Prophet Muhammad himself introduced many changes and reforms. So, at the time of the death of the Prophet in 632, what was Islamic law like? There were many pre Islamic practices, rules, and regulations that were accepted by the Quran and the Prophet, as well as the changes the Quran and the Prophet brought in. After the death of the Prophet, the new Muslim state, based in Medina, had to deal with a whole range of new challenges and issues. Muslims moved out of Arabia into new regions in the north, northeast, and northwest of Arabia. They interacted with different cultures and civilizations: Christians, Zoroastrians, and others. They interacted with different systems of administration and justice that existed in those newly conquered regions. Part of this move of Muslims into these regions was coming into contact with different legal systems and the different rules and regulations that existed in these new areas or regions. The Muslims and the Muslim state accepted many of those rules, regulations, laws, and systems they found beneficial, which did not contradict basic Islamic ideas and practices and laws and rules. Often, the Quran and the Prophet was silent on many such matters. What this means is that what was acceptable as Islamic law expanded significantly after the death of the Prophet Muhammad. When Muslim scholars were developing their system of law in the first 200 years or so, which we now call Islamic law, they had this huge body of material to rely on, not just the texts of the Quran and the Hadith. Of course, at the center of this was the instructions, rules, regulations, and texts and ideas provided in the Quran and the traditions of the Prophet. But as you can see, there were many other sources they relied on to construct the system of Islamic law. For our purposes, what is important is how the Quranic texts were interpreted in the development of or construction of Islamic law. We will deal with this topic of interpretation in a number of other lectures. But here I would like to give you a sense of one area of law that the Quran was particularly concerned about, and also to give you a rough idea of some aspects of this particular area of law. Let us now focus on the teachings of the Quran in relation to women and the kinds of reforms the Quran introduced, by way of example. Obviously, this will be a brief overview. If you ask a Muslim what pre-Islamic times were like as far as women were concerned, one popular view among many Muslims would be something along these lines. Women in general were disadvantaged in pre-Islamic Arabia. Female infanticide or killing female babies was perhaps common. Women did not have property rights, or women were unable to inherit from their parents. The number of wives was unrestricted, so any man could have any number of wives. The situation was difficult for widows and orphan girls, and the Quran and the Prophet changed all of that. This is, of course, one way of looking at a very complex situation in Arabia at the time. True, there were these practices, but it does not mean that the entire pre-Islamic Arabian population, that is, all tribes, practiced all these in the same way. Or the situation of women throughout Arabia was like this. These were practices that existed, but side by side there were also many practices that contradicted these practices. As students of the Quran, we should be careful not to overgeneralize when it comes to such matters. History is always a lot more complex than we might think. Well, there were exceptions. By way of example, let me just mention one. Although many women did not have much power or access to wealth, say for example in Mecca, there were women who did. The best example is the Prophet's own family. The Prophet's wife Khadija was a businesswoman and a trader. She had wealth and power. In fact, the Prophet himself was employed by Khadija, that is his wife, in her business. She was the one who supported the Prophet in ways that are not often appreciated well. Imagine what the Prophet's mission would have been like without her extremely important support, both financial and emotional. It is also good to point out that in the two towns where the Prophet Muhammad lived, that is Mecca and Medina, even there were significant cultural differences between them as far as women were concerned. In Medina, women were more assertive. In Mecca, probably husbands had more control over their wives, if we could use that term. We do have echoes of that in the Quran and also a number of anecdotes about this situation in Islamic historical texts. So the situation in Mecca and Medina were not uniform. Let us look at some examples of the changes the Quran introduced in relation to women in that context, that broader context. Obviously, there was a lot of disadvantage when it comes to women in that context. Because of this, we do find a lot of references in the Quran asking Muslims to change quite a lot of their practices. The Quran wanted to address those pre-Islamic practices and norms concerning women that were contrary to its egalitarian spirit. For example, in the Quran, women and men are considered equal as far as their humanity is concerned. chapter 4, verse 1 says, "People, be mindful of your Lord, who created you from a single soul, and from it created its mate, and from the pair of them spread countless men and women far and wide." The Quran says men and women are created from a single soul, so there is no sense that either party was created inferior to the other. There were also legal changes the Quran introduced. Female infanticide was prohibited. Orphan girls' rights were protected. Mistreatment of women in marriage was also prohibited. Women could not be forced into marriages by their fathers or relatives. Women's acceptance became an essential part of the Islamic marriage contract. Women were permitted to inherit. The idea that a woman could inherit was problematic for many pre-Islamic men and tribes because, from their point of view, women did not create wealth nor contribute to the creation of wealth in their societies. The idea that a woman could inherit was problematic for many pre-Islamic men and tribes because, from their point of view, women in their societies did not create wealth nor contribute to the creation of wealth in their societies. The idea that a woman could inherit was problematic for many pre-Islamic men and tribes because, from their point of view, women did not create wealth nor contributed to the creation of wealth in their societies. It was men who went to war and brought back booty. So the question was, why should women have any share of inheritance? But the Quran said that that was unfair. So it changed that. Men and women were to get a share of inheritance. In another case, whatever the husband gave to his wife as bridal gift, or mahr in Arabic, was for her to keep as personal property. The husband could have no share of it or take it back, according to the Quran. While it was previously paid to the bride's father as a gift, the Quran said it should be retained by the woman, not the father. The Quran also gave women additional property rights. Polygamy was limited to 4 wives by the Quran. More importantly, even though the Quran seems to be tolerating marriage of a man to up to 4 wives, it also said that a man should marry more than one only and only if he can be fair and just to all wives. At the same time, the Quran said that if one cannot be fair and just, then he must marry only one. So even this verse that seems to allow polygamy, on a closer reading, it is not a general instruction or encouragement for Muslim men to marry more than one wife. The verse seems to be taking into account the social situation in Arabia at the time, given that there was no social security system as we know it, and many men probably got killed in battles, leaving large numbers of women and families without any financial support. In such a situation, then, from a Quranic point of view, it is important to provide the necessary support for these women. Marriage perhaps could provide that support in that society. But it is also very concerned about the issue of justice and fairness. So it keeps emphasizing the need to be fair and just. This issue of justice is a huge topic in the Quran. There were many injustices towards women, for example, in divorce situations, and the Quran attempted to address what was going on. So these are just some examples, but there are plenty of other reforms the Quran introduced in relation to this specific part of the community, women. A lot of what the Quran did can be considered very radical at the time. For example, property rights for women. That was perhaps unthinkable in many societies 1400 years ago. But the question is, did Muslims actually continue with these very radical reforms and changes the Quran introduced after the death of Prophet Muhammad? The answer is to some extent yes. From a strictly legal perspective, if we follow the letter of the law, they did follow many of these reforms. But in practice and in spirit, some of the pre-Islamic practices and attitudes towards women were revived later and continued until our times. And this can be seen in many Muslim societies even today. But like many other areas of society the Quran was dealing with at the time in relation to women, the Quran did not attempt to change everything. Many reforms like inheritance and property laws were radical, but the Quran probably saw there were limits to what it wanted to do or could do at the time. Let us not forget that we are talking about 7th century Arabia, not 21st century Australia. The socio-historical context I talked about in earlier lectures is extremely important in this context. The Quran was dealing with a whole range of issues by keeping an eye on that context as well. So, in summary, this lecture has explored the issue of the Quran and law. It has tried to explain how the Quran is not, strictly speaking, a legal text, but that it does address many legal issues. The jurists had to use the legal verses or texts of the Quran and, of course, the traditions of the Prophet to develop a system of law to encompass all aspects of a Muslim's life. To do this, they drew on other norms and values and sources of law from the surrounding communities, including pre-Islamic Arabia. The Quran's approach to law was sometimes to leave the existing norms and ways of doing things in place if they did not contradict its basic message and its norms and values. At other times, it clearly reformed practices and norms it felt were unjust, unfair, and I gave the example of its changes in relation to women and women's rights, for example. Thank you for watching. Stay tuned for more lectures in this series as we explore the Quran's history, themes, and interpretation, as well as related debates today. Subscribe and turn on notifications to catch the next lecture in the series.